opinions and statements made by the host and participants in this program are not those of the owners, advertisers, and management company of Sugar City FM 90.3. Nor are such statements necessarily supported or endorsed by the owners, managers, or advertisers of this station. While we encourage all to share their opinions, we do not support any comments that may slander, discriminate, or otherwise offend anyone, and we insist that you refrain from any such statements.
Welcome to the Customer Support Portal, where we have made it easier for you to contact us. It starts with your question, email, a message, phone call, or a search on our website. Our CSP provides prompt and efficient solutions to your problems. We pride ourselves on treating our clients responsibly and ensuring your information is kept safe. Log on to www.skndb.net and send us a ticket or email us at customersupport@skndb.com. You may also call us directly at 869-465-2288, extension 1322 or 954-353-1003.
If you have a dream, what are you waiting for? The Development Bank has what you need and more. We aim to build stronger communities. That's why we have so many opportunities. Business loans, student loans, we make a positive difference in your life, in your life, in your life, in your life. Yeah, financing your dream home, we make a positive difference in your life, in your life, in your life, in your life. Yeah. Development Bank of St. Kitts and Nevis. We make a sustained positive difference in your life.
Fellow citizens, near and far, join NewRish Nital on Sugar City 90.3 for Fear No Fun. Tune in to 90.3 on your FM dial. Go on to sugarcityfmstkids.com or download some radio app from the Google Store. And NewRish Nital every Thursday night from 8 to 10 p.m. as NewRish Nital tackles the issues and football. Fear no favor. Every Thursday night from 8 to 10 p.m. on Sugar City 90.3 FM.
Good evening and welcome to Fear No Favor. I decided going forward that occasionally I would be dealing with some legal issues or legal topics. And tonight would be one such occasion. We have quite a lot going on in our society, St. Kitts Nevis. And I think it is only fair to have discussions, general discussions, nothing specific to what is actually happening with respect to the facts, but general discussion. Now, I want to start out by looking at homicide. Homicides are unlawful killings. The major categories are murder, manslaughter, and causing death by dangerous driving. Let's repeat that. Homicides are unlawful killings. The major categories are murder, manslaughter, and causing death by dangerous driving. Murder, a common law offense, is the unlawful killing of a human being under the Queen's peace with malice aforethought, so that the victim dies within a year and a day. A year and a day. Actus reus. The killing must be of a human being. The unlawful killing of an unborn child, therefore, is not murder and is covered elsewhere. And we'll look at that sometime in the future. Under the Queen's peace simply means that the killing of an enemy in the course of war will not be. The killing must be unlawful. Certain defenses, for example, self-defense, will make a killing lawful. The death must occur within a year and a day of the defendant's conduct. This is a historical leftover from the days when causation was often more difficult to prove, but it is still a requirement for the offense. Although the Law Commission in its report number 230 has recommended the abolishing of this requirement or the abolition of this requirement. Menswear. Menswear generally is dealt in greater terms, and many of the points made, they are particularly relevant to murder. The menswear for murder is defined as matter of forethought, but it has been unclear in the past exactly what this means. Its meaning has been made clearer by recent House Lords' decisions. And the authority on this is Maloney, 1985. Maloney, a soldier, had become involved in a heated discussion with his stepfather about guns. His stepfather had tested him that he would not dare to fire a live bullet, at which point Maloney fired a loaded shotgun at him and killed him. The case turned on the definition of malice aforethought and the interpretation of previous authority, such as I am. The House of Lords held that nothing less than intention to kill or cause grievous bodily harm would constitute malice aforethought. I shall repeat. The House of Lords held that nothing less than intention to kill or cause grievous bodily would constitute malice aforethought. Merely foreseeing the victim's death as probable was insufficient, and on that basis, the conviction for murder was quashed and a manslaughter conviction was substituted. Those are just some preambles. And our thing tonight is really self-defense, but I want to touch on a few areas to sort of whet your appetite before our discussion. And one such thing that I want to look at is provocation. Under 3 of the Homicide Act of 1957, where on a charge of murder, there is evidence on which the jury can find that person charged was provoked, whether by things done or by things said or by both together, to lose his self-control, the question whether the provocation was enough to make a reasonable man do as he did shall be left to be determined by the jury. And determining that question, the jury will take into account everything, both done and said, according to the effect which, in their opinion, it would have on a reasonable man. Provocation as a means of reducing murder to manslaughter existed before the Homicide Act, but the rules were much more restrictive in terms of the scale of reaction, the kind of provocation, and the proportionality of the reaction. The Act makes it clear that jury must decide the case on matters of fact. Above-mentioned matters would merely be of evidential value for the jury in deciding whether the defendant was provoked and whether a reasonable man in his position would have reacted as he did. The defendant does not have to prove provocation. If the jury has a reasonable doubt as to whether he was provoked, he is entitled to the benefit of it. Even if he himself does not raise the defense, it is up to the judge to do so in an appropriate case. So, if evidence suggests that provocation could have been given in instructions to the jury, even if the defendant or even the person child did not speak about provocation, it would be the duty of the child judge to bring it up in summation to the jury. Okay? So we looked at provocation, and we wanted a few examples with respect to provocation. We're looking at Cambridge, 1994. These, usually for the individual as these defense to a murder charge was that he was not the attacker at all, and he therefore did not raise provocation as a defense, although there was relevant evidence. So this person, 1994, had a case, and there was sufficient evidence for him to raise the defense of provocation. However, he did not. His appeal against conviction was allowed because the judge should have put the possible defense before the jury. So even the defense lawyer does not bring up the issue of provocation as a defense. The judge was supposed to put it to the jury. And we have to be mindful. Some people like to say, well, your lawyer didn't bring it up. Well, the judge has a responsibility. In this case, they had sufficient evidence to bring up provocation. But the good gentleman did not bring it up, but he appealed his conviction. And the appeal against the conviction was allowed. In other words, the conviction was quashed. Another case, 1994, that of Struck. D was a paranoid schizophrenic who killed her husband. She refused to plead diminished responsibility at trial, but tried to introduce it on appeal. The Court of Appeal dismissed her appeal, saying she was competent to make that decision at trial and could not change her mind now. There was no question of judicial responsibility to raise the issue independently. Loss of self-control is an immediate response, but That is not required as a matter of law. It is a question of fact whether it was the provocation which caused the loss of self control. And the closer they are in time, the easier it is to prove. If you provoked and you committed the murder, the space in between, if it is very close to the time you were provoked, then it is easier to prove that provocation would have been responsible for that. So don't leave and go home and spend some time and come back later on. Mind, that can work sometimes because you'll hear about examples of that situation. But the closer it is in time, the provocation and the crime committed, it is easier to prove provocation. In 1992, there was a case. He set fire to her husband while he was sleeping. She had been a victim of domestic violence for many years, but her response to her husband's violence was not immediately following any specific act. A while ago, I said that the closer the provocation, with the time of the criminal, the easier would be to prove that provocation caused it. But here we're talking about a situation, our next case, where the lady set fire to her husband while he was sleeping. She had been a victim of domestic violence for many years, but her response to her husband's violence was not immediately following any specific act. The appeal held that there must be a sudden and temporary loss of self-control, but it need not immediately follow the provocative act or acts. So even though there must be a sudden and temporary loss of self-control, it does not necessarily would have to follow a specific act. And I'll explain a little bit more. Nevertheless, it was held that there was no misdirection on the point by the trial judge. The courts are now much more willing to take into account the history of violence in such cases. So in this particular case, they say, okay, she didn't act immediately. Some time went by. But there are situations where the violence could accumulate, and then at a particular event or after a particular act, it could all come out. When that lady lost that case and said that there was not any misdirection, which was what the judge told the jury, they got through with that. Her conviction was upheld, but a warning was given. The courts are now much more willing to take into account the history of violence. So you could have had about 20-something things happening to you. You never acted on number one. You didn't act on number two. You didn't act on number three. You did on 25. But then on this 26th occasion, everything bottled up inside you. And for all what you were going through, with the prior acts of violence against you, on the 20th occasion, you killed the individual. In 1995, Humphreys, the victim was a drug addict who had raped, beaten, and terrorized this lady for a period of time and had threatened her on the night she killed him. She was convicted or murder, but the Court of Appeal held that the victim's behavior over a long period should have been stressed because it could build up and culminate in a final act of provocation. Also relevant were these psychiatric history and abnormal personality stemming from the abuse, and this should be put in to the reasonable person. So all the things he used to do to this woman, raped her, beat her, terrorized her over a long period of time. On this particular occasion, when she eventually killed him, they are indicating that cumulative effect could be provocation. So we have to be careful. And sometimes you are taking advantage of someone, a male taking advantage of a female over a period of time. It could interfere with her mental state. And that is why they said that her psychiatric history and abnormal personality stemming from the abuse. When you abuse people, they cannot continue as if nothing happening. It would bottle up inside them. They might not be willing at a particular time or many times before. And as such, you might have felt as if you have the license to continue treating this person. On this particular occasion, you were killed by the female. Because people's minds get messed up over a period of time from domestic abuse or physical abuse, mental abuse. And it could cause them to behave sometime after in a way that can be detrimental to the perpetrator. So we have to be very, very mindful of the cumulative effect of knocking about our females. An important question is, was the defendant provoked? This matter is judged subjectively. The judge will decide whether there is sufficient evidence on which a jury could find provocation. And he must leave the matter to them. In other words, he would do his own analytical work based on his knowledge, his experience, and his examination or perusal of the evidence. And if within himself he's convinced that there is evidence, well, he must leave it up to the jury to decide. He must put the issue to the jury, even if the defendant does not raise it himself or herself. It is then up to the jury to decide whether the defendant was in fact provoked. If he or she was not, it is irrelevant that a reasonable man would have been. If they have called reasonable and they look at it in a certain way when you're having a criminal matter. Would a reasonable man, okay, for example, if somebody is intoxicated, the reasonable man might be somebody who is sober. Would a sober individual did what the intoxicated individual did? Just to give you a sense of what reasonable would mean. And they're saying that even if a reasonable person would have been provoked based on all the circumstances. If that individual was not provoked, it is irrelevant that a reasonable man would have been. You might have 50 reasonable persons. Based on the circumstances, you work out that none of them would have been, or all of them would have been provoked. But this particular individual, number 51, was never ever provoked. So you cannot look at it and say, well, since reasonable persons would have been provoked, that by extension you put that situation to the defendant, because people deal with things differently. People have different coping skills. On average, you could infer that a reasonable man would have been provoked based on the circumstances of the case. But if that person is stronger, because remember you have persons who will be way stronger than a reasonable man on certain circumstances. Some would be way weaker than a reasonable man. Others would be just on par or about with the reasonable man. So if you were above par and the circumstances did not provoke you, it is relevant that a reasonable man would have been. Just trying to make sure we understand as we go on, because provocation could be technical. There is another example from 1992. Rosita. D was a victim of domestic violence over a period of years. They used D as just to represent the subject. D was a victim of domestic violence over a period of years. In response to an attack by her husband, which was not life-threatening, she lost control and stabbed him many times, killing him, of course. Her defense of self-defense was rejected by the jury, but on appeal, the Court of Appeal held that according to Section 3 of the Homicide Act, it was the duty of the judge to put the issue of provocation to the jury, even if not raised by the defense. There was evidence on which a jury might find she lost her control, self-control, and therefore a verdict of manslaughter was substituted. They convicted her of murder. And her thing was self-defense. But she failed to convince the jury that she was defending herself. And the defense, the perpetrator and her lawyers, they appealed the matter. And the Court of Appeal, which is the higher court, indicated that even though there was no substance for her to go on with respect to self-defense, there was sufficient evidence to use provocation. And even if the defense did not bring it up, it was the duty of the trial judge to put it to the jury that there was provocation. And as such, the murder conviction was reduced to manslaughter. These things are so interesting. Very, very, very interesting. Let us take a break, acknowledge our sponsor, and come back.
If you have a dream, what are you waiting for? The Development Bank has what you need and more. We aim to build stronger communities. That's why we have so many opportunities. Business loans, student loans, we make a positive difference in your life, in your life, in your life, in your life, yeah. Development Bank of St. Kitts and Nevis. We make a sustained positive difference in your life.
Welcome to the customer support portal, where we have made it easier for you to contact us. It starts with your question, email, a message, phone call, or a search on our website. Our CSP provides prompt and efficient solutions to your problems. We pride ourselves on treating our clients responsibly and ensuring your information is kept safe. Log on to www.skndb.net and send us a ticket or email us at customersupport@skndb.com. You may also call us directly at 869-465-2288, extension 1322, or 954-353-1003.
Fellow citizens, near and far, join NewRish Nital on Sugar City 90.3 for Tune in 90.3 on your FM dial.
Welcome back to Fear in Our Favor. And then we are going to get into what this session was supposed to be about. Self-defense. But of course, you saw from the last example that even if you tried self-defense and there's sufficient, and failed with it, but there's sufficient information to suggest provocation, then the judge would have to instruct the jury. That is why I dealt with provocation before, because it missed one catch the other, and we'll now go into the self-defense area. A defendant has the defense if he or she uses necessary and reasonable force in any of the above private defense, in this case looking at self-defense. So a defendant has a defense if he or she uses necessary and reasonable force to defend himself or herself. That is key. That is the foundation to our discussion going forward. It must be necessary. You must use necessary and reasonable force. And this is part of the common law and partly supported by Section 3, Subsection 1 of Criminal Law Act 1967. Let us reiterate that the defendant has a defense if he or she uses necessary and reasonable force to defend himself or herself. And this is controlled partly by common law and partly by Section 3, Subsection 1 of the Criminal Law Act 1967. Authority on this. If the defendant makes a mistake as to his right or her right to self-defense because he or she is voluntarily intoxicated, however, the circumstances will not be viewed through his or her eyes, but through the eyes of a sober person, as the mistake will not be admissible in evidence. Even, and let me say she, because right now is a situation of she pervading our society. Even if she does not raise self-defense at her trial, the judge should do so in any appropriate case, wherever it is applicable. The judge can put it to the jury. And what is the authority on this? What case went by in the past that tell us that this can happen? What case went by in the past? DPP versus Bailey, 1995. D was a special constable in Jamaica who became involved in a struggle with two people. He said they tried to take his gun, and in the struggle, he shot one of them. He was found guilty of murder, never having argued self defense at his trial. The Privy Council held that this conviction could not stand because there was evidence on which self defense could have been raised, and the trial judge should have put it to the jury. Very, very important. Even though he was committed of murder and he did not raise the issue of self-defense, that had to be the judge erred in not putting self-defense to the jury. Really erred in doing that. So we cannot continue to say that his defense team should raise the issue, and if they do not raise it, then it is bye-bye. No? Privy Council held that this conviction could not stand, such the conviction, because there was evidence on which self-defense could have been raised, and the trial judge should have put it to the jury. He examining the facts, he getting all the facts there. And he knows the law. The law is for him. Or both law and facts for him. The facts most are for the jury when they want to deliberate and answer what's going on. But he has to lead the jury with respect to legal issues. Now, reasonable force. This is always a troublesome area because some people feel that some calculation must be done. Just inferences would be drawn. People might feel that you should have used 6 pounds of force to hit your opponent, but instead of 6 pounds of force, you used 10 pounds of force. And this is where the problem would come in. And it is difficult. You can calculate at that point in time under all that stress level, how much force should I apply to defend myself? But it is the law. Let us look at reasonable force. A person can only use such force as is reasonable in all the circumstances, and it is up to the jury to decide whether it was, as it is a question of fact and not law. So, given all the circumstances, when the jurors would have heard the evidence, the facts of the case, they are the ones who would decide whether or not you use reasonable force or you went beyond the degree of reasonable force. That is why they say you have to be adjudicated by your peers. Person who think and behave like you would be placed in the same bracket per se, if you can think about it in layman's term. We don't know anything about the law, share anything about the law, hear anything about the law. We just hearing the facts. And those are people who are not trained in law. So those are your peers. Put it this way. Maybe something happened in your class at school and you have to go to court. Your classmates, so to speak, could be considered your peers. And those are the ones who they would use to sit on the jury panel to adjudicate your matter. Just to put it in simple terms. Now, the authority for reasonable force is Byrd in 1985. The case of Byrd in 1985. They had been slapped and pushed by a man. She was holding a glass in her hand at the time, and she had hit out at the man in self-defense. So you slap and push the lady, she hit out at you. She had a glass in her hand. The trial judge directed the jury that self-defense was only available as a defense if the defendant had first shown an unwillingness to fight. So it seems as if this trial judge was indicating that the person coming up to you, showing you fight, you must as much as possible try to evade the individual before you can come to the court and say that it was self-defense. But we'll understand better as we go on. That is not really the case. So it's be back, evade, dodge there, dodge cross there before you could use the defense of self-defense if you happen to kill somebody because they assaulted you, they injured you, they caused you harm, and this automatic response. So you're doing me all kind of thing, and I must sit down as if I studying for an exam and relaxing, evading you, trying to not get into any problem with you. And this is what this trial judge is saying. Run. Even if you're in a small room where you can't even turn around in, run. The trial judge directed the jury that self-defense was only available as a defense if the defendant had first shown an unwillingness to fight. The Court of Appeal quashed the conviction. So, well, this ain't any conviction. We're going to throw this. Saying that it was unnecessary to show an unwillingness to fight. And there were circumstances where D might reasonably react immediately and without first retreating. It was up to the jury to decide on the facts of the case. So the appeal court said, no, Mr. Court Judge, no, it cannot be like that. She must not initially just shy away from an opportunity to defend herself or to get involved in an altercation. It could happen on the spur of the moment in a very quick time. So if it happens on a very quick time basis, how could you initially show a willingness not to partake in that altercation? Yes, that was thrown out. That conviction was thrown out. Then in 1995, in the case of Scarlett, you have preemptive self-defense. Preemptive. And you'll get the gist of what that is really means. It is not absolutely necessary that the defendant be attacked first. In some circumstances, he or she may act preemptively to prevent an attack. You could anticipate an attack because of what all you're getting in your mind and how you see things coming. You'll be preemptive, and take the necessary precaution. I thought this is the Attorney General, reference number 2 of 1983. An individual can protect him or herself in advance from an attack. For example, by arming himself or herself, or even making a bomb. And this can constitute self-defense. So if you calculate everything, and within your mind you turn over possible circumstances, you do your permutation and your combination, and you get results showing you that you could be attacked. You can, in advance, prepare yourself for such an attack by arming yourself. You can even make a bomb, and this can constitute self-defense. So you don't always have to wait until somebody attacks you. You must have some history of how that person operates, either with you or against you, and you prepare yourself. Next thing, if you do something and the person got killed, there is a question whether or not that was premeditated murder. But you just have to peruse the circumstances, and things would be cleared up in the minds of the jurors. And I guess a just verdict would be passed. What about excessive force? We spoke about reasonable force. But the question is, was the force excessive? One has to be very, very, very careful. Like I said a while ago, if you applied 10 pounds of force and it is felt within the minds of the jury that 6 pounds would have been adequate, the fact that I went over that can be considered excessive force. But who has time to do the calculation when one is being attacked? The use of excessive force indicates that the defendant has acted unreasonably in the circumstances. So from the time they decide or they infer that force, like in the case of me, the force that I used was 10 pounds. If they calculate that was excessive, that means that I would have acted unreasonably given the circumstances. But that is so interesting. There will therefore be no valid defense. If the force was excessive, there will therefore be no valid defense, and the defendant will be liable for the crime. Oof, I call for a drink of water, boy. You have to ensure that whatever you do to protect yourself, that it is not excessive. This may seem rather harsh in some circumstances, particularly on a murder charge. If a defendant acts under provocation, for example, and kills someone intentionally, you're provoking me, I make up my mind I'm going to kill you. Because you're provoking me. The provocation would have reached a height. So I'm going to kill you. So I intentionally killed you. That charge of murder is reduced to manslaughter. You see? If you were charged for murder and you were provoking, it is found that you were provoking and provoking till it reached a particular height, unbearable height, and I made up my mind that I'm going to kill you, and I do that. That is what I mean by intentionally. And kill someone intentionally, a charge of murder is reduced to manslaughter. But we have to be careful. That is provocation. Going back to self defense. There is no similar rule with regard to excessive use of force in self defense, even though there may be a considerable overlap between two situations. Even though you might have some commonalities between that crime over there and this crime over here, a very large common area. But one was due to provocation. Even though you intentionally kill the person, the murder charge would be reduced to manslaughter because of the fact you were provoked. However, if you use excess force in dealing with any situation, even in self-defense, there may be a considerable overlap, but there is no such thing that the murder charge would be reduced to manslaughter. It can be done that way if there is provocation, and provocation was proven. If it was self-defense and you use excessive force, there is nothing that can be done to reduce that murder charge. That's the disparity, that's the difference, that's the distinction between the two. Provocation, your murder charge reduced to manslaughter, but excessive force, a murder charge shall remain once it is found that you use excessive force. So sometimes the lawyers would have to be very, very, very careful as to which defense they are going to use. But like I said before, you might have gone for self-defense, but then there's sufficient evidence, and the judge who's supposed to be the man with sagacity within the court trial, would identify the evidence which will speak to provocation. So even though you did not raise the issue of provocation, you might have lost on the ground that you could not prove self-defense. But however, provocation could be the perfect defense for you. And that murder charge, I mean, you can get away, but that murder charge as well would be reduced to manslaughter. And the authority with this excessive force is this. Mac Innes in 1971, they was involved in a fight between two rival gangs. This person was involved in a fight between two rival gangs. He had a knife, and he claimed that his victim ran on to it. He had a knife, and the victim ran into him, ran onto the knife, and caused his death. He appealed against conviction, saying that his direction on excessive self-defense was wrong in law. So that particular gang member, at trial, apparently when the trial judge was giving his summation, he would have mentioned that that perpetrator used excessive force in self-defense. The Court of Appeal held that there was no provision for murder to be reduced to manslaughter in such circumstances, but a defendant cannot be expected to act coolly and calmly in this kind of situation or to measure his response accurately. And that is what I'm talking about. So you cannot measure it. I cannot say, well, you know, it takes 6 pounds of effort, 6 pounds of force. I can. And you're trying to punish me because I used 10 because 6 could have done the same job or was sufficient for me to defend myself. No, they said no. You cannot expect the defendant to be calm in this kind of situation or to measure his response accurately. A jury must take into account the fact that the defendant acted on the spur of the moment, under stress. And if they felt that he acted honestly, then this would be strong evidence of reasonableness. Yeah, the Court of Appeal telling you have to take things into consideration. A man is under stress, but he must calculate might of the blow that he's going to give the individual because he does not want it to be excessive or to be considered excessive. The Court of Appeal said no. Court of Appeal said no. And if they find that that perpetrator was being honest, then this would be strong evidence that he acted reasonably. The court also pointed out the possibility of provocation as an alternative defense, but we've been talking about that all night. Self-defense doesn't work, then you try provocation. The effect of this approach towards reasonableness is generally more favorable to the accused than an alternative verdict of manslaughter would be, as it will almost always lead to an acquittal, where a verdict of manslaughter would be brought in if it were available. However, in principle, excessive use of force in self-defense is considered no defense. And if it results in death, constitutes murder. That is where the difficulty is here. Once it was excessive, there is no defense for that. And I reiterate, however, in principle, you have some lawyers that are great, they have to do. But in principle, excessive use of force in self-defense is no defense, and if it results in death, constitutes murder. I have a 10-year-old son, and on several occasions he asked me about this. He said, if people attack you and you get the upper hand and you kill them, would they lock you up? I mean, at 10, he asking you this question because apparently there were some guys who feel as though they could have taken advantage of a family member of his. And he asked that question. And he asked me that several times because he is maybe turning over in his mind. He would not like his brother to go to prison, but he would not like them to get any upper hand of him because he would like his brother to do what he has to do to defend himself. And I think about the seventh time when he he asks about self-defense. If you're not supposed to defend yourself when people are attacking you. So you see, even at that age, there's a concern. Do you stay there and take licks and maybe increase the probability of you getting licks to the extent where you're crippled or you die? Or should you retaliate sufficiently to incapacitate the attackers? And if you do that, and the unfortunate situation of one of the attackers or the attacker losing his life, why should my brother go to jail for that? So even at that age, persons are digging for answers. Persons are genuinely digging for answers. And that is why there's a need for persons who know this thing to come out and give explanations. I'm absolutely certain that he's up listening via stream, because I think the radio aspect is down due to an outage, Beaufort and Frigate Bay area. But I'm confident that he's looking at it. He never did miss a show. So I guess tomorrow he'll be asking me some more questions. But I think I'm reasonably clear enough for even him to understand. Let's look at the authority with respect to this excessive force. You have Clegg in 1995. A soldier had fired at a stolen car being driven towards him at a checkpoint and killed a passenger. So you had a soldier there standing, and the car was moving in his direction towards him, and he fired his weapon and he killed a passenger. The House of Lords confirmed his conviction for murder. You see that? Even though the car coming towards you, and there's a very high probability that the car could lash you, injure you, to the extent where you might even die. He appealed after they convicted him. He appealed, and the House of Lords confirmed his conviction. In other words, they upheld the conviction for murder because the trial judge had found a question of fact that the amount of force used was unreasonable and excessive. Wow. Then we have to ask ourselves a question. At what point should he defend himself? Or should he just run away? Avoid the confrontation, avoid the oncoming vehicle. At what point? Sometimes we behave as though persons have a weekend to think about what they're doing. This was rather unfortunate. And somebody might say, well, if he could not get the full self-defense, couldn't it be a partial self-defense? Well, let us see about that. A soldier had fired at a stolen car being driven towards him at a checkpoint and killed a passenger. The House of Lords confirmed his conviction, or they upheld the conviction for murder because the trial judge had found a question of fact that the amount of force used was unreasonable and excessive. Their lordships refused to bring about any change in the law by introducing a partial defense. That is what I was just mentioning. If they could not give him a partial defense. And they said the lords refused to bring about any change in the law by introducing a partial defense, reducing liability to manslaughter. But why did they do that? You know why? They indicate that that was the job of Parliament and not the court, however desirable the change might be. So even though the Lordship, the highest court in the place, even though they realized that there's a need to introduce partial self-defense, they couldn't consider that with respect to addressing the soldiers' appeal because it is not in law. So they're saying to the appropriate authorities, the parliamentarians, go to Parliament and introduce this aspect of partial self-defense because the more cases apparently go through, is the more they realize the need for something like that. And that is why they said it was for Parliament and not for the courts, however desirable the change might be. Don't care how much you want it. It is not for the court to, at an instant, consider partial defense. Okay, we look at reasonableness in self-defense. If a defendant makes an honest but reasonable mistake, honest but reasonable, no, if a defendant makes an honest but unreasonable, even though he was honest in his thinking, it was unreasonable, a mistake as to whether he has right to defend himself, then he lacks the mens rea. That is the mental aspect. They have mens rea and they have actus reus. You have the mental state and you have the act itself. If a defendant makes an honest but unreasonable mistake as to whether he has a right to defend himself, then he lacks the necessary mens rea as to the unlawfulness element and will not be guilty of an offense. You're honest, but your thinking was unreasonable. You make an unreasonable mistake. And if you do that, that means that the individual lacks the mens rea as to the unlawfulness element. Remember, crime will have certain elements, but that element of unlawfulness is lacking, and therefore that individual will not be guilty of an offense. If a defendant makes an honest but unreasonable mistake as to the degree of force he can use, strictly speaking, this is excessive self-defense, and he will still be guilty of the offense. You see, they're trying to bring out something here, and I want you to get it. Two situations, similar. The defendant an honest, in first instance, the defendant makes an honest, don't care how unreasonable that mistake was, as to whether he had the right to defend himself. They are saying that that individual lacks the mens rea, the mental aspect. As to the unlawfulness element, and will not be guilty of an offense. It was honest, but it was highly unreasonable. You would not be liable. You would not be guilty of an offense. But when come now to the excessive, the same condition, if a defendant makes an honest but unreasonable mistake, same thing like above, as to the degree of force he can use, he miscalculate. How hard should I hit him? How much shots must I give him? So he miscalculated. Strictly speaking, this is excessive self-defense. Even though he was honest in making this unreasonable mistake, strictly speaking, this is excessive self-defense, and he will still be guilty of an offense. So when come to that excessive force, they're not playing with it. So people, just a light moment, walk with your calculators. Get involved in your physics and what force to apply. Make sure you look at people and study them carefully. Oh, he look bony, he look skinny. I mean that I have to give him about 2 pounds of force to knock him out on the ground. So stop short of killing the individual. Calculate the force properly. Calculate the force properly. So then the person would fall to the ground, and then what? You call police for the individual? What do you do after that? What about those karate stars who would have studied the human anatomy to the extent and the network of it, to the extent that they know precisely we inflict the best possible injury. I don't know if you could say best possible injury, but the worst possible injury on an individual. And then you look at those karate pictures and you see the grandmaster just take his index finger and hit you some spot by the chin or somewhere, and that can put you down for quite some time. Could even kill you. Could that sensitive application of force based on the knowledge, even though the force might be, well, I don't even know how they would handle this, even though the force seemingly was just like the brush of a fly, what would the court decide on that? It caused death. But because it caused death, would it be considered excessive? Where the excessive comes in. Job falls short of death. Get the guy hospitalized, ICU unit, intensive care unit for a week, 2 weeks, put him on medical, put him on surgical. What is short of excessive? And could that slight touch by someone who masters neurology, nerve ending, the anatomy, could that slight touch that caused death be considered excessive? That is a question I would really like to pose to the authorities. Just a slight touch, a brush of a feather. It's like taking a feather, maybe hitting somebody across the face with it, and you end up with a few broken bones. I'm sure persons within the court confine would be laughing at that. But that's a situation you have persons well trained as to how and where. Let me not say hit, touch you. Is there anything excessive in a touch? Is it the results that will determine if something was excessive? Even though we could observe that it was the slightest of touches. Suppose we had persons who can traumatize you to the extent where your life is taken, and you approach one such individual and they hypnotize you. So without touching you, that person utilized a particular aspect as self-defense, and it caused your death. Could that person be seen as inflicting excessive force? What was the force? That is something else. Really, really something else. Somebody did do something, and I would like to know, is obby legal in our federation? Somebody could have done you something, and you could have visited the obby man because you want to bring about some hurt to that individual. Suppose that obby man brought about hurt to your opponent. Is there anything in law that can cause you to take criminal action against the perpetrator? They say obia is real. They say it is even in the Bible, biblical teaching with respect to that. But can someone be punished for inflicting harm or injury on an individual by utilizing that modality? And could that individual, if someone, perpetrator, attacked and they were able to do whatever they have to do quickly and impose harm, cause death of that individual, without, maybe without touching the individual, could that be considered excessive? Those are questions. Those are questions that person will have to ask. Could it be considered as excessive? So is it the result or the poundage you knew, the force applied in self-defense? that they would consider excessive. Let us take a break, acknowledge our sponsor, and come back.
If you have a dream, what are you waiting for? The Development Bank has what you need and more. We aim to build stronger communities. That's why we have so many opportunities. Business loans, student loans, we make a positive difference in your life, in your life, in your life, in your life. Yeah, financing your dream home, we make a positive difference in your life, in your life, in your life, in your life. Yeah. Development Bank of St. Kitts and Nevis. We make a sustained positive difference in your life.
Welcome to the customer support portal, where we have made it easier for you to contact us. It starts with your question, email, a message, phone call, or a search on our website. Our CSP provides prompt and efficient solutions to your problems. We pride ourselves on treating our clients responsibly and ensuring your information is kept safe. Log on to www.skndb.net and send us a ticket or email us at customersupport@skndb.com. You may also call us directly at 869-465-2288, extension 1322, or 954-353-1003.
Fellow citizens, near and far, join NewRish Nital on Sugar City 90.3 for Fear Nor Favor. Tune in to 90.3 on your FM dial. Log on to Sugar City FM or download your app from the Google Play Store. And join NewRish Nital every Thursday night from 8 to 10 p.m. as NewRish Nital tackles the issues and take your call. Fear No Fever every Thursday night from 8 to 10 p.m. on Sugar City 90.3 FM.
What are you waiting for? The Development Bank has what you need and more. We aim to build stronger communities. That's why we have so many opportunities. Business loans, student loans, we make a positive difference in your life, in your life, in your life, in your life. Yeah, financing your dream home, we make a positive difference in your life, in your life, in your life, in your life. Yeah. Development Bank of St. Kitts and Nevis. We make a sustained positive difference in your life.
Welcome to the customer support portal, where we have made it easier for you to contact us. It starts with your question, email, a message, phone call, or a search on our website. Our CSP provides prompt and efficient solutions to your problems. We pride ourselves on treating our clients responsibly and ensuring your information is kept safe. Log on to www.skndb.net and send us a ticket or email us at customersupport@skndb.com. You may also call us direct at 69465-2288, extension 1322, or 954-353-1003.
Fellow citizens, near and
Welcome back to Fear Nor Favor. Now, some persons would have a question about, suppose a person was intoxicated. So maybe I should look at that particular aspect with the remaining time. Or even if we have a little bit more time, I would like to touch the precise issue that is prevailing in our environment. Now, voluntary intoxication for Dutch courage. If the defendant deliberately gets himself intoxicated or drunk in order to give himself the courage to commit an offense, which he subsequently commits when so intoxicated that it might be had to prove he had the menswear at the time, he will be unable to claim lack of intent, even in respect of a crime of specific intent. You're saying you're drunk? So from the menswear perspective, you're basically claiming that you did not know what you were doing. You did not have the intent because you were in such a state that you could formulate the intention. Right? You cannot formulate the intention. And that is why you hear people talk about Dutch courage. Voluntarily drinking your rum to get drunk, get the courage to do what you wanted to do, that you never had the courage to do while you were sober. And that is why they have here voluntary intoxication for Dutch courage. So we heard some courage. It's like a constructed courage, catalyzed by the consumption of alcohol. If the defendant deliberately gets himself intoxicated in order to give himself the courage to commit an offense, which he subsequently commits when so intoxicated that it might be hard to prove he had the menswear or the state of mind at that time, he will be unable to claim lack of intent, even in respect of a crime of specific intent. Then you have intoxication and defenses. But let me look at the authority on that one about voluntary intoxication. The Attorney General for Ireland versus Galakfa in 1961 decided to kill his wife. He brought a knife and a bottle of whiskey, which he drank to give himself Dutch courage. Then he killed her with the knife. The House of Lords held that he was guilty of murder and could not to lacked intent or being insane. That's voluntary intoxication. And you did what you have to do. You purchased a knife. You took in your rum, became intoxicated, became drunk, and then you took that same knife and killed your wife. But you cannot claim that you did not have the capacity to formulate the intent. You chose to get drunk. So the House of Lords said nothing to Augusta. And that is the case of Attorney General for Northern Ireland versus Gallagher, 1961. So you get time, you can look up that case. What about intoxication in general? The Court of Appeal has considered the question of the relevance of intoxication when a defendant was relying on a defense of self-defense. So somebody was relying on self-defense. The person was intoxicated. Given the subjective approach to this, as evidenced by Beckford, the approach to intoxication could make a difference to liability. The Court of Appeal rejected the relevance of the distinction between crimes of basic intent and specific intent when it came to defenses, and said that a mistake arising from voluntary intoxication could never be relied on in putting forward a defense for crime. Once you voluntarily got intoxicated, there is no defense rule that the court would accept, regardless of what crime you committed. This was a novel extension of the rules relating to voluntary intoxication. Now let us look at the authority on that, or several authorities on that. O'Grady in 1987. D, because of intoxication, mistakenly thought he was being attacked by a friend and reacted violently, causing death. D was convicted of manslaughter and appealed against the conviction. He was relying on the defense of self-defense in the circumstances as he mistakenly believed them to be. So thought he was being attacked, and he reacted violently. Those thoughts pervading his mind at the time, and he tried to appeal. This case evoked considerable criticism for its approach because the court dismissed the appeal for the very same reason above. You got yourself intoxicated. This case evoked considerable criticism for its approach. It was reconsidered by the Court of Appeal in a later case, and its decision highlighted the inconsistency of the earlier case. There's the next authority, O'Connor in 1991. D, while drunk, headbutted his victim, who died. D claimed he thought he was acting in self-defense. He was convicted of murder and appealed on the grounds that his misbelief was relevant. The Court of Appeal held that whereas, following O'Grady, there was no need to mention the intricated mistake in respect of the defense of the self-defense. It should have been mentioned in the context of proving the specific intent necessary for murder. His conviction was quashed and a manslaughter conviction substituted. It was clear from Beckford and from O'Grady that the same issue could be looked at alternatively as either a question of mens rea as to the unlawfulness or the defense of self-defense. It is unacceptable that a different result can be reached on the same facts depending on which approach is taken. So you're saying you can formulate the intent and then you want to use the defense of self-defense, and they say you ought not to be able to reach a different result depending on which approach used. And then the last authority, Jagad versus Dickerson in 1981. Dee broke into a house which she thought belonged to a friend of hers, who had given her permission to treat the house as her own. That mistake, though, caused by voluntary intoxication, was enough to exculpate the defendant by allowing her to rely on the statutory defense of lawful excuse under Section 5, subsection 2 of the Criminal Damage Act. Because the test specifically set out in subjective terms, the court held that the reason for a subjective belief in lawful excuse were irrelevant and the defendant was acquitted. This case is relevant only to the specific defense of lawful excuse under the Act and has no wider application, cannot apply to anything else. Well, we will have looked at intoxication. We first looked at murder, the actus reus, the mens rea, and then we look at provocation. We say provocation reduce a murder charge, a murder conviction to a manslaughter. And then we look at self-defense. We're saying whereas provocation could reduce to manslaughter, there is no such provision in the law to reduce excess self-defense. Well, from the time you have excess self-defense, you apply excess force, then you have no defense at all. They're saying self-defense cannot be reduced from murder to manslaughter, but the defense can make use of provocation. Okay, we have a local situation where a young lady was involved in a homicide. We have many views, many persons making predictions, and many debates taking place. The thing about it is that we do not know all the circumstances, and one must be careful. You can make general suggestions or give your opinion, but we do not know all of the specifics. And as such, we cannot be unguarded in our utterances. Persons were basically rejoicing when the young lady was released. But one must be mindful that even if the police release you without charging you, there is not the grounds for celebration because it is not over. You have to be aware that the police would not keep you in custody past 72 hours. And as such, they are compelled to either charge you or release you. So that was the case. She was not charged at that particular juncture, and she was released. Now, one thing we have to understand is that the police could have done that for a number of reasons. It could be, like I said, the 72-hour period came upon them. They might not have fulfilled most of the investigations that they would like it to be. So it was compulsory that at that juncture, wisdom dictated from a legal perspective, you release the lady without charge. The police might be trying to make sure. You see, information is okay, but information is quite different from evidence. And we have to maintain that distinction. Information is different to evidence. And the police might have been getting information, but they're now trying to get it constructed into evidence. How do you make that transition? How do you use information as opposed to evidence? Information could be transformed into evidence, and some cannot. Because even though some people have information and they don't want to come forward, then the information will just remain information. Now, they would have to make up their minds as to what charge they would impose on the young lady. There might be a possibility that they would have released her so long until they can gather sufficient evidence to formulate the appropriate charge. Because it would not make sense charging somebody for murder without knowing the precise facts. So they have to take the time, go through, have the meetings, the trained police officers, get all the information, gather the information, and then they would make a decision. They could decide, okay, based on what we know, we're going to charge for murder. Based on what we know, we cannot charge for murder. Based on what we know, it could be a charge of manslaughter. Because we have to understand that it is not the police job. Well, eventually it might be the police job because what they gather the information, compile the file, send it down to the DPP and ask for some guidance by way of advice. The DPP might say you have sufficient information to build a case. The person may be charged. But when they send the file, they might say, look, we intend to charge for A, B, C, or just A, or just B, or just C. They might ask the DPP, those charges are appropriate based on the information that we sent down. The DPP might respond and say, look, you could charge for A, but you cannot charge for B or C. Or you cannot charge for A, and you cannot charge for B, and you can't even charge for C. So it doesn't make sense we're going through this case. Or the case could go down to the DPP, and the DPP might decide that they're not pass the case based on the evidence that they have. Then the case could go upstairs, go high court, and the defense might decide, look, there's no case to be answered after the prosecution would have presented its case. The defense may put in an application for no case submission. And I just exploring certain possibilities so people could understand. So the police could be taking their time. It could be the police after they done gone through everything to have the young lady rearrested and this time charged and do a speedy bail hearing to put her back out on the road maybe the very same day. But it is very difficult that somebody would have lost his life and it was decided that absolutely nothing should be done. That is not the decision of the police like that. A life was lost. Something would have to happen. But to what extent, to what degree, we do not know. Because we do not know all the circumstances. But something would have to be done. So even though at this moment she is free, not charged, at any time later, could be tomorrow, next week, next month, she could be rearrested and charged. And they would decide whether they would offer bail or object bail, and all this would come from the total circumstances of the incident. They would decide whether or not they will object to bail or they will facilitate bail and facilitate it expeditiously, that we go pick her up Friday, have a charge, arrested charge, and to walk with her sureties and be processed quickly maybe go back out the same day. Or if they have reasons, because we do not know, if they have reasons to object bail, her lawyer would have to convince the High Court judge that she's no threat to anybody. She would comply with the bail conditions and whatever else. And then the judge, in his own wisdom, based on the information presented by both sides, decide whether or not he would grant bail or he would deny bail and give his reasons. Now, the very delicate situation we're going through, a life was lost, and seemingly, just from general hearing, that the young lady would have made several reports. Several reports. Remember, we said in provocation that you could be. I read the. So we looked at the situation where the person was abusing his wife for a long period of time, many, many occasions. And even though she did not retaliate on any of the previous occasions, on this particular occasion, she did retaliate and kill the husband. And the court would have said that that accumulation of knockbout, of violence executed on the lady was sufficient for her to have lost control and act in self-defense. So things could be building up over a period of time, a protracted period of time. And on this one occasion, decided she lost control. Not she decided, she lost control and killed. Before, in earlier cases, they indicated that the time frame between being provoked and responding, or losing control and responding, the closer it was, the easier it would have been to prove that provocation was the cause of death or the action of the perpetrator against the victim. But then they said no. It could happen over a period of time. Over a period of time. And just happen on a day after the 50th time, the 40th time, the 30th time, the 20th time, the 10th time. And that 11th occasion, she did what she had to do. But whatever, there would be a process. There would be a process. Her lawyers, our lawyer, they are intelligent people, they're experienced people. But I believe that a particular aspect of the defense team would be to call a psychologist, not a psychiatrist, a psychologist, and ask about post-traumatic stress disorder. The young lady could have been experiencing trauma. And whenever she encounters a trigger, it might have effectuated a response of life or death, either my life or your life. Because that's how triggers operate. And if I see you coming towards me or engaging me with some brutal lashes and whatever, that might be a trigger to trauma that she's already experiencing because it was done to her many times before. So the psychologist would want to indicate that those triggers cause her to re-experience the previous traumas that she would have gone through and cause her to lose control and maybe acted out in self-defense. Or I say it could be provocation. But I think that a smooth play would be to engage a psychologist, engage a psychologist to talk to the possible traumas that she would have experienced and the triggers and what could have been infuriated as a result of being re-exposed to those triggers. Everybody waiting to see what would transpire. We have to always put our best feet forward in defending the life or the liberty of an individual. There'll be many stories. Many persons, maybe the police logbook would be used to show the many reports. Many other persons could provide collateral information. Some of it would be circumstantial evidence as well. Some people might come forward. Some people might have information but do not want to come forward. So a lot of things, we are not sufficiently au fait. So, and neither are we au courant with whatever development. So it's a wait and see. The police are the one who are investigating. Police should not be doing things to get a feather in the cap with respect to a conviction. What they should be doing is doing a thorough investigation because they should be advocates of justice. If there is evidence to exonerate the perpetrator, those evidence must not be withheld. Evidence must be given in its totality to compile the file and get some advice from the DPP office. It is a waiting game. It's an unfortunate situation. Very, very unfortunate situation. And we have to be mindful that there would be a process one way or the other. One way or the other. Some things like that, even if they convict you of manslaughter, and then you get a year, 2 months, 3 months, 4 months. Because we have to understand that it's not like just walking. You cannot have a society like that where you just walk. Something happen and a process will have to take place. Whether the defense wins the case or the person is convicted, you have your character witnesses, you have the whole set of circumstances, and whatever sentencing. I'm of the strong opinion that it cannot be murder with limited information. So whoever know better would be in a position to formulate whatever they have to formulate. But at the end of the day, let us that justice would be served. Justice should be served. It's not a matter of if somebody did something. It's a matter of the circumstances that would have led to the end result. We're hoping that we can learn sooner rather than later and the legal minds are already doing what they're supposed to do in order to ensure that justice would be served. I'm not a lawyer. I'm just a holder of a law degree. But I think that those legal minds already started to work. Okay, I think that we are coming up on the end of this session, and I would like to thank those of you who messaged. I know we could not follow by radio because the outage would have impacted negatively the transmission via that particular medium. But we are hoping that who normally listen by radio and didn't quite get it, they might be able to get close to a computer. It would be on Facebook, and they could have a listen, because some of the information was reasonably important. And as a society, if you absorb that kind of knowledge, you could better understand various things. And thanks to the technician who would have sat here throughout the 2-hour period. And also thanks to the sponsor, the Development Bank, for the continued supply of oxygen to sustain an all-important program. Thank you.
The opinions and statements made by the host and participants in this program are not those of the owners, advertisers, and management company of Sugar City FM 90.3, nor are such statements necessarily supported or endorsed by the owners, managers, or advertisers of this station. While we encourage all to share their opinions, we do not support any comments that may slander, discriminate, or otherwise offend anyone, and we insist that you refrain from any such statements.